Okay, good afternoon and welcome to the HUD CARES Act Virtual Training Conference 2022. This session that you are in will address a variety of related other federal requirements that are important to consider when you're using CDBG funds or CDBG-CV funds to implement your housing, community, and economic development activities. We're going to cover a lot of ground in this session, so put your seatbelts on and get ready to ask some questions and learn some new things, and hopefully we'll point you to some additional resources as well. Next slide. All right, a little bit of housekeeping that we'll get out of the way up in front. The PowerPoint presentations and the webinar and the recordings will be available on HUD Exchange. So all of the presentation materials that you're seeing for the conference this week, it's all going to be accessible. Don't worry if you can't furiously take notes on every little thing that we cover and everything that's discussed in the session. It will be available for your reference later. Participants will be in listen-only mode during the presentation. Closed captions can be viewed using the show captions feature below the video player. You got the little green button there below the live stream. Consult the attendee guide for more information available on the resources page of the event website. So in that screen where you're watching me, to your left, you're going to see a resources icon where you can click and look at the attendee guide to get additional information. Next slide, please. Okay, so questions. There will be questions, and there are in every session. We're covering a lot of technical content, so questions are not uncommon. If you do happen to have a question, we ask you to submit your content-related questions using the Q&A feature. So just below the live stream window, located below the video player, you would need to scroll down your web page for most monitors to view the Q&A. So you'll see the image on my slide here. It's pointing to a Q&A button. That is through Slido. You are all encouraged to submit questions throughout the presentation. You don't have to wait until we finish talking. You don't have to wait until the end to submit your questions. We're happy to go ahead and set up as many questions as we can answer. If you see a question that is in the Q&A already, when you click that Q&A button that you also need an answer to and are interested in hearing an answer to, please go ahead and click the little thumbs up button. It looks like what you see on your screen there, icon that's next to the question, and that's going to help Randall and I to prioritize answering those questions that have the most interest. So if you all can help us out with that, we'd certainly appreciate it. Next slide. So in the chat, participants may request assistance for any technical issues through the chat box that's located to the right of the live stream window. A member of our support team will be happy to assist you. If that's not successful, you can also send an email to eventsupport@sitemgroup.com and a representative will be glad to address your technical issues. Next slide. All right, getting back to questions. So if you'd like to access questions and polls while simultaneously viewing the event so that you don't have to scroll down and miss the exciting action here on screen, you can do a couple of things. You could download the Slido app on your phone by going to sli.do in your web browser, then type in the code for this session. The code. The support team is posting the Slido code for this session in the chat right now. You can also scroll to the bottom of the page to find the Slido code in the session description. So if you don't want to do that scrolling up and down, you can log into Slido in a different window or on your phone or another device and be connected to that Q&A. All right, let's go to our next slide. Okay, so with those housekeeping details addressed, introduce myself. My name is Clint Whited. I'm Senior Vice President with MDG Associates, LLC. With me today is Randall Mullen, who's Vice President of TDA Consulting. Our companies are both part of the HUD Technical Assistance Team that's helping states, counties, and cities administer and implement Community Development Block Grant and CDBG-CV funds to address the impacts of the COVID-19 pandemic. Without further ado, other federal requirements. So many of these other federal requirements that you see on screen, we will colloquially refer to them as cross-cutting requirements, apply to most or all of the community planning and development programs offered by HUD. We are in this session going to provide a very quick overview of the requirements that you see on screen here. There is far more detailed training available in the HUDexchange.info website for each of these topics. Effectively, we're covering 3 to 5 weeks of training for these requirements summarized into a 2-hour session. So there is a lot to learn in each of these areas to develop expertise. So, kind of buckle up. We're going to cover the highlights for you, point you to resources, point out hopefully some of the more important things that you should know as you're considering CDBG and CDBG-CV activities, so that you can get to the point of knowing, I think lead-based paint requirements or lead-safe housing rule would apply to this. Let me go check. So we really want to promote awareness of the other federal requirements and help you to build familiarity with these. So it will be a bit of an overview and not necessarily a deep dive into all of the financial management concepts of 2 CFR Part 200. The key that you need to remember is that once you invest CDBG or CV funds into the project, that first dollar that you invest in the project infects the entire project. So, the other federal requirements are a huge consideration for grantees who are determining how best to invest their resources to address the impacts of this pandemic. Next slide. So we are diving right into the requirements with environmental review. So the first rule of environmental review is that an environmental review is required as soon as you invest that first dollar, actually before you invest that first dollar of CDBG or CDBG-CV funds. A lot of CDBG today. I've never seen these requirements waived for a HUD program. Environmental is attached to every dollar that moves in this program. And the purpose of the environmental review process is to analyze the impact a proposed project will have on a community where that project occurs. Grantees may not spend either public or private funds, whether it's CDBG, CDBG-CV, other federal money, other non-federal money. Really, you can't do anything. You can't execute a legally binding agreement for property acquisition. You can't commence with construction or rehabilitation work until the environmental clearance has been achieved. There are different levels of environmental review. We'll touch on those, but it's very important to make sure that you are in good standing and that you have documented your environmental review before you proceed with really anything on a project, before you commit CDBG funds to a project, before you spend CDBG funds, before you make any choice limiting actions on a project. So in an environmental review, the impact on the environment exists when a grantee is considering, as an example, let's say we wanted to build a community center, but it just so happens that our available site is on a wetland. Might not be a good idea because we're going to have a negative impact on the environment. The impact on the environment has to be considered. There are situations where what you're planning to do seems all well and good, but there are rare species that are nesting there at certain times of the year. That's where mitigation measures come into play and some more advanced environmental topics. The other way that we look at this is in the inverse. It's impacts from the environment that might impact the project that we're proposing to build. Such as building a high school on a site that's a former oil site that has a giant methane plume beneath it. Might not be the greatest place to build your project or your community center or your affordable housing development. So when we're thinking about environmental, we're thinking about what our impact on the environment will be, but we also need to consider what the impact of the environmental conditions at that site will be on the beneficiaries, the people, the residents that will be benefiting from the activity. And as you know, a wide variety of activities in the CDBG program, which means there are a lot of different considerations from an environmental standpoint that are appropriate for different activity types. We'll touch on a little bit of that today with the levels of review. So 24 CFR Part 58 is the HUD regulation for environmental review under the National Environmental Policy Act. It prohibits us from committing or expending CDBG funds until the environmental review process has been completed. And if required, the grantee has received its authority to use grant funds from HUD. So there's a process that you go through, and we'll get into that in just a moment. The environmental review page on the HUDexchange.info website is constantly being updated with new resources. There are partner worksheets that help you with all of the different environmental factors that you're asked to consider in the different levels of review. So you may not have expertise in wetlands, you may not have expertise in historic preservation, but there's a wealth of information and resources and videos and guides and links to data sources available on the environmental page at HUDexchange.info that could take someone that knows nothing about the National Environmental Policy Act and give them some tools to be able to navigate some of the lower levels of review and to start to understand what really goes into considering our impacts on the environment or impacts from the environment. So definitely encourage you to check that out. Take a look at the WISER trainings that are available for that purpose. All right, let's go to our next slide. Okay, so HUD's regulations, laws, and applicable authorities. Important to consider that Part 50 is for HUD. It is the environmental regulation that governs projects that are implemented by HUD. The reviews are prepared by HUD staff. So if you're a grantee of the CDBG or CDBG-CV programs and you're looking to Part 50 for guidance, it's not the best place to go procedurally. Part 51 talks about man-made hazards, environmental review factors related to noise, acceptable separation distance from explosive hazards or above ground storage tanks for fuel, airport hazards, those runway clear zones. Unfortunately, my hometown has a small airfield, and they've been in the news lately. They've had a couple of crashes there in Southern California. So taking these things into consideration, where your project site is, what you're building there, who's using it, and what's going on in the environment around it. Some view it as a lot of paperwork and research, but it really does have an impact on everyday people and their lives, and it warrants careful consideration up front by following these regulations and the NEPA review process. 24 CFR Part 55 and the executive orders 11988, 11990 deal with floodplain management and wetlands protection. You all have probably heard about Hurricanes Harvey, Irma, and Maria in 2017. And, to say that floodplain management is an important issue in the state of Texas or other places that have low-lying areas is an understatement. So floodplain, flood insurance, elevation standards, you need look no further than some of the devastation along the Louisiana coast last summer in the hurricane season. I think Lake Charles was hit twice by hurricanes, separate hurricanes. So we need to consider all of these things: floodplain management, floodplain elevation. So Part 55 is covering a lot of information in that area. Part 58, that is, I think, for compliance folks, for CDBG staff, for CDBG-CV staff, of grantees, of states. This is really where we want to zero in, because Part 58 goes over National Environmental Policy Act environmental reviews for what's called a responsible entity. If you are a city and you're receiving entitlement CDBG funds, sorry, I've got to clear my screen here. I had a pop up. So if you're an entitlement city and you're receiving CDBG or CDBG-CV funds and you're administering that grant under agreement with HUD, you are the responsible entity, which is another way of saying that you are the entity that is accepting the jurisdiction of the courts. You are the entity that is responsible for preparing the environmental review, whether it's categorically excluded, whether it's exempt, whether it's subject to 58.5, which we'll touch on a little bit later, or whether it's an environmental assessment. or even an environmental impact statement, your city or county is considered the responsible entity as the recipient of the grant from HUD and is responsible for preparing that environmental review. And there are situations we'll talk about in a few minutes where you will then package that environmental review and put it through a noticing process and submit that review and the results of that noticing process to HUD to get HUD's authority to use grant funds. It's not required for all of the different levels of review, but for certain projects it is, and so we'll touch on when that's appropriate and when it's not. As I mentioned, 58.5, there are, in part 58.5, there are 17 different related laws and authorities that you're evaluating when you have an environmental review that is categorically excluded subject to 58.5. The abbreviation for that is CEST. So CEST, you're looking at 17 different environmental factors. All of the things that I mentioned a couple slides ago that we're taking into consideration from an environmental standpoint, either impact on the environment or impact from the environment. Those related laws and authorities are taking us to places like wetlands, explosive and flammable materials, floodplain, historic preservation, airport clear zones, a number of different factors that I can't recite from memory, but they're there and they'll all be evaluated when you're using that CEST form. Another level of review that is a bit more common with, let's say, administrative activities, your public service, human service activities, things that really aren't going to have an impact on the built environment. It's the CENST, or the categorically excluded not subject to 58.5 category. And so that's where you're either documenting an exemption or a categorical exclusion, and you're evaluating far fewer than 17 related laws and authorities. From memory, there are 2 or 3 related matters that you're addressing on those forms for CENST. So it's important to look at Part 58, look at the training on HUDexchange.info, appropriately determine the level of review you need to engage in, and then use those HUD Exchange resources. If you're working on a review that's subject to 58.5 and those 17 related federal laws and authorities kick in, it's going to definitely be important to take advantage of some of the modules and some of the forms, the partner worksheets that guide you through the different considerations and data sources to be able to respond one by one to those 17 related federal laws and authorities. A lot of interesting environmental issues have come up as a result of the pandemic and as a result of some of our efforts to address homelessness with things such as non-congregate shelter and other activities that may not have been prevalent considerations across the country. So environmental review, I cannot understate the importance of either knowing a lot about this and doing it well, or making sure that within your organization there's a staff person or that you have access to some expertise to be able to document your reviews on time so that you don't have project delays. But I think more importantly, to make sure that the environment is not suffering as a result of our actions, and that we or your residents or businesses are not suffering as a result of environmental factors that exist at sites. Let's move on to the next slide. All right, so there are certain limitations prior to clearance. So here's the rule. No recipient or participant may commit or expend HUD or non-HUD funds prior to receiving state or HUD approval if the activity would have an adverse environmental impact or limit a choice of reasonable alternatives. So when we're talking about a participant, we got to unpack a little bit here with some of the terminology. A recipient, if you're an entitlement community, you are the recipient of CDBG funds from HUD, the city, the county, the urban county, the town. If you're an entitlement community and you're receiving an entitlement grant, you are considered the recipient. If you are the participant is referred to as a public or private nonprofit or for-profit entity or their contractor that may be participating in the review or in the activity. any activities that are not exempt or categorically excluded, not subject to 58.5 can proceed. Effectively, what you're doing is you're documenting that the project is exempt or categorically excluded. You can sign off on that review as the responsible entity. You've designated a certifying officer or responsible entity certifying official that will sign off. Usually it's the chief executive of the organization of the responsible entity that would be signing that, unless there's a delegation letter. It's actually a sample delegation letter on the HUD Exchange site that you can use if someone like your planning manager or community development director typically signs off on the environmental reviews. But if you've got an exempt activity, a public service, an administrative activity, something of that nature, document the exemption and then move on. There aren't any noticing requirements. You don't have to get an authority to use grant funds. Those are really simple and straightforward reviews. If you have a more complex situation, a rehabilitation, public facilities improvement, site acquisition in anticipation of building a homeless shelter, it's going to require a higher level of review. You're starting to get into that categorically excluded subject to area where you're reviewing the 17 factors. You're getting into that area where it could elevate to an environmental assessment. So you're looking at those same factors, but also taking an enhanced look at the mitigation measures that come out of the project. So there's a lot to unpack there. But the key thing is, if your project is one of those things that's subject to 58.5, so some kind of an impact on the physical built environment, you need to make sure that you stop all activity that could limit your choice of reasonable alternatives. Something I learned from a colleague recently, we're working on a multifamily disaster recovery housing program. And I'm not an expert in floodplain, but learned from a very wise consultant that as part of your floodplain analysis, there is a situation where it's appropriate and required to conduct analysis of alternative sites to see if they would be more suitable. Now, if you've already committed funds in an agreement to a developer and committed to a site, you've now eliminated your choice of reasonable alternatives to address the environmental impacts on the environment or impacts from the environment that project may suffer. So very important to not make any decisions, obligate funds, or commit HUD funds in any way to those types of projects until you've got that environmental review completed and you've got clearance. Next slide. So classifying the activity. So I jumped the gun on this a little bit. I've thrown around some terminology. We'll run through them quickly here. Exempt is going to be your activities that are typically administrative in nature, your public services, your human services. Categorically excluded subject to or not subject to is a dividing line that, I guess in layman's terms, is the difference between impacting the built environment or not impacting the built environment. There are categorical exclusions for things like home buyer assistance or emergency rental assistance. Activities that are a bit more than exempt, but not rising to the level of a not subject to, or of a categorically excluded subject to. All of those are documented in the regulations at Part 58, and so it's a matter of really appropriately classifying your activity between exempt, categorically excluded, subject to or not subject to. So there, as you can imagine, there are forms for all of these things, and those activities that require environmental assessment. So something that, give you a couple of examples. Is exempt CDBG administration, CDBG-CV administration, CDBG public service food bank, paying for just labor supplies to distribute food. Categorically excluded subject to might be certain rehabilitation, like an owner-occupied rehabilitation project that meets certain criteria. Categorically excluded subject to might also include like reconstruction or rehabilitation of community centers, sidewalks that existed. Environmental assessment, when you graduate to that level, you're really looking at new development. whether it's on an existing site or whether it's on a greenfield. Anything that is new built environment, new development that we're introducing really kicks into the environmental assessment category, because you're going to want to evaluate the impacts much more fully than something that may have already previously been vetted, something that's already part of our environment. If you're looking at an activity that requires more than one, or that could go one way or the other, conservative advice here, go with the level of review that is the most stringent, or consult your environmental specialist in the local field office or your regional office. You can also request technical assistance on the HUDexchange.info website if you do get into a pickle and have a difficult time determining what the appropriate level of review is. Training materials on the site are also quite useful. And I would advise you to take your determinations activity by activity. Don't make too many assumptions until you're sure, and you're looking at the form and you say, okay, yeah, this fits best in this category. This is the level of review we're going to engage in. And if you're unsure, consult with HUD, consult with the resources, or if you need to move forward today, then go with the more stringent category. Next slide. Project aggregation. This comes up quite a bit. So you need in your environmental review to group together and evaluate as a single project all of the individual activities that are related or logical parts of composite or contemplated actions. So that's a mouthful. A couple of different ways to look at this. You could look at it functionally, or you could look at it geographically. So we're looking at aggregation. What we're talking about here is functional aggregation being the phasing of the project. So we're going to build 250 units of multifamily housing in downtown Los Angeles. We are investing funds in some offsite infrastructure. We are investing in really anything having to do with the project to that magnitude, but the project is being phased. We're going to build 100 units today. We're going to build 200 units 3 years from now when we get the additional subsidy for the project. The environmental review that you perform, if you're required to perform an environmental review at the outset of that project, needs to take into consideration functional aggregation, the entirety of the planned undertaking. So if you're doing an environmental assessment for phase one, that environmental assessment should contemplate what is planned for that site or for that project for phases 2, 3, and 4 as well. So do the environmental review for the whole planned undertaking if there are phases that are functionally codependent, that are aggregated together. Another way of looking at that is geographically. Geographic aggregation means projects that are taking place in the same geographical area. So we're going to build a structure on this site. Let's say it's a homeless navigation center, but we're also planning to perhaps acquire an additional site to be a food bank. And we envision these activities operating kind of codependently. We anticipate owning both sites and operating those sites. You would want to consider geographically all of those things that you're planning to do in that place that are related to one another. Your environmental review should take all of those things into consideration. Don't just use kind of tunnel vision and say, nope, today I'm building a navigation center with 30 SRO units, or and tomorrow we'll deal with the food bank. You need to look at the entirety of the undertaking. Don't just pick the part that's CDBG funded. That's also a big mistake. Saying, oh, well, we're only investing federal funds in this part of the project, ignoring that other parts of the project that are regulated by other funding sources could be doing significant damage to the environment, or that environment can be doing significant damage to us. And if we just ignore it because we're not funding that phase or that part of the project, it's setting us up to fall down, setting us up to fail. And there are significant risks associated with that. So understand the whole picture. Don't just focus in on one part of it, because important things will end up being missed. Next slide. HEROS, the HUD Environmental Review Online System. It is a system that HUD developed. It is a comprehensive online tool that also walks us through the environmental review process. So all of the forms that I mentioned that are on hudexchange.info, those are all built in to HEROS. Some of the links to resources to evaluate the 17 related environmental laws and authorities are accessible through HEROS. It kind of guides you step by step through the review process and facilitates your access to resources when you need them. Also, it is quite helpful in that it allows HUD and responsible entities to share documents with folks and third parties. And finally, it facilitates electronic submission and certifications to complete your reviews. So a lot of what was a paper process becomes an electronic process, and HUD was working on this well before the pandemic. HUD's using it under Part 50. It is still currently voluntary for Part 58 reviews, but if you're not using the system, highly encourage you to take a look at some of the HEROS webinars on our website, on the hudexchange.info site, and go ahead and sign up and try it out. Quite helpful, great resource. Not currently mandatory, it is voluntary, but you know, if you're just now learning to do NEPA reviews and you don't already have your forms and templates and resources lined up, highly encourage you to just go ahead and get signed up for HEROS and learn it that way. That is our future. So it's my plug for HEROS. Next slide. Environmental promulgation. So promulgate. We are going to let people know about things that are important to them that they may not be aware of, but for our notification. So publishing notices in a newspaper of general circulation or posting notices in prominent places. This is outreach. This is letting the public know that something is happening. It's required. That's where the newspaper of general circulation comes into play. Because it's not just about outreach and awareness, it's also about the law and legal requirements and legal resource. There's a reason why, as a responsible entity, you're accepting the jurisdiction of the courts. Environmental matters, it's not uncommon for those to be litigated. And as a responsible entity and at the Department of Housing and Urban Development, we are all in a better situation when an appropriate environmental review is completed fully. Prior to making any choice limiting actions, that it's noticed, and that you have your authority to use grant funds. So we talk about environmental promulgation. It's about making people aware of things, making them aware that there is an environmental review that has been completed, that there has been, so you got some acronyms here, FONSI, NOI, RROF, and forgive me if I've used these without defining them, occupational hazard here. A FONSI is a finding of no significant impact. That is an environmental determination that you would make after you finish your environmental assessment. So those larger scale reviews, those more in-depth reviews, the environmental assessment would hopefully, if all goes well, result in a finding of no significant impact. You would then publish a notice of intent, which is letting the public know that you intend to do something. You've reviewed it. The documents are available as specified in your notice, and that you intend to do something, and that something is the RROF. That's not a dog barking, roof. It's a request for release of funds. So again, more administrative procedures, but the request for release of funds is a submission of your notice and proof of publication to HUD if you're an entitlement grantee, to the state if you are a sub-grantee of the state. If you're receiving state CDBG funds or a CDBG-CV award from your state, they would be the ones in a position to issue an authority to use grant funds on your environmental. You can send copies of that environmental to other agencies and interested parties. Really, this is about letting people know that you've completed your review, transparency about the review, that it was made available, people had a chance to inspect it, and offer comments on that review prior to you making that submission to HUD and getting authority to use grant funds. Once you have that authority to use grant funds, you've made the environmental review available. maintain that documentation, maintain the records. Should a need arise to, or some type of challenge arise or some type of suit, those are often called upon to resolve issues. What did you know? When did you know it? Why did this site flood? Did you do your 8-step analysis? Things of that nature. So it's required. Make sure that you're letting the appropriate people know about your environmental review and your planned project at the appropriate time. Next slide. The environmental review record. So we just came off of the national objectives session. For those of you that joined us for that, welcome to this. Document, right? You know, if you haven't documented it, did it really happen? I don't know. And neither will your CPD representative, neither would the inspector general, or neither would the courts. So make sure that you are always maintaining a written record of compliance with all applicable environmental requirements. Record keeping there at 58.38 in the regs. Legal challenges are won or lost based on the completeness of the environmental review record. It's a fact, and it's why you know, large-scale contractors, developers, people with serious money and serious projects invest so much time and effort and funding into the environmental review, because you don't want to be down the road having invested, you know, lots of money in a project, particularly CDBG or CDBG-CV funds, that wasn't appropriately assessed for environmental compliance. Your records need to contain all of the documentation. So start with your review form where you're recording your determinations and citing the sources that you consulted to reach those determinations on the 17 factors that we discussed. Include project descriptions, maps, pictures, anything that you have readily available that describes completely what the undertaking is. Include your forms and checklist. Use the HUD recommended formats. There's a lot of old stuff floating around out there. Make sure that you're checking in, you're getting the most recent format. If you don't want to worry about that, sign up and use Heroes, always an alternative, and then you can't go wrong because you're operating within the latest and greatest HUD system for completing National Environmental Policy Act reviews. Make sure you've got copies of your notices if you're doing that categorically excluded, subject to 58.5. If you're doing environmental assessments, make sure you're keeping your notices, your notice of intent to request, your notice of intent, finding of no significant impact, request for release of funds notices, and the proof of publication, since it's required to be done in a media of general circulation, newspaper general circulation. Keep all correspondence and relevant documents. Word of advice here, don't rely on hyperlinks and websites exclusively. If you're preparing that environmental review, download a copy of what you looked at so that you know that on, you know, January 27th, 2022, I looked at the FEMA website and the map said this, or I looked at the State Department of Fish and Wildlife website and it said this about the site I was building on. Because oftentimes websites change. How often is the HUD website updated, and a resource you're looking for might have moved. You know, we try to stay on top of that, but that's kind of the nature of the beast. So although, you know, hyperlinks are great, you know, it reduces paper burden. If you can download and save a PDF copy with your environmental review record, it will 100% beyond a shadow of a doubt be there for you later, whereas hyperlinks, things come and go and could create extra work for you down the road should you need those source documents that you based your decisions on. Public comments, you got to maintain your public comments. So if you've published your NOI, FONSI, ROF, and you're in that 15-day public comment period locally before you send it off to the state or send it off to HUD, if you receive comments, you need to package those comments, address them, and also include those with your submission to HUD or to the state. Similarly, if HUD or the state receive comments during the review and comment period that's specified in your notice, those would also need to be addressed during that time and before you receive your authority to use grant funds. Lots of environmental stuff. I feel like we're doing environmental training here. Let's go to the next slide. All right, learn more. I've mentioned these websites. I'm going to put it up on screen. HUDexchange.info, programs. You click programs at the top, click environmental. the whole world of environmental review is there for Part 58. The WISER webinars, mentioned those. Again, you're going to hudexchange.info, you're going to programs, you're clicking environmental review, and then there's training right there for you, videos and different modules you can go through. There are regional and program specific live trainings. HUD's Office of the Environment offers a lot of trainings. If you're subscribed to the HUD Exchange email listserv, you probably get announcements from time to time of specific things that are going on in your region. We don't all live in the same place, and the United States is a huge country. So, you know, paying attention to things that are impacting you regionally is important, and there may be additional resources available to you at the local or state level that we're not talking about here in a national level training. And then finally, your regional and field office environmental officers, like I mentioned earlier, just an invaluable resource. Again, they're not just there to come out and monitor you every few years and tell you that your forms are lousy or that they're deficient. These are passionate individuals who care about the work, they care about people, and they want to get you where you need to go. Sometimes their answer isn't always convenient. Sometimes it's not always quick to implement. Sometimes we don't always agree with it. But it really does behoove you to make sure that you're partnering with your environmental officers when necessary to make sure that you get it right, because a lot's riding on it. You know, it's people, it's the environment, it's the earth. So don't hesitate to reach out to those folks. They're good people, very knowledgeable, and they can get you where you need to go. Next slide. All right, labor standards, Davis-Bacon. So we see some contractor types, developer types, architect types huddled around a set of plans. Labor standards, as it would suggest, has to do with labor, in this case, construction labor, and in this case, construction projects. The Davis-Bacon Act is a prevailing wage requirement. It applies to all CDBG, CDBG-CV construction contracts over $2,000. So you have CDBG, CDBG-CV funds in a construction contract. So those funds are paying for a construction contract, and that contract is over $2,000. The prevailing wage requirements of the Davis-Bacon and related acts apply. That prevailing wage requirement requires that workers on the project are paid at least minimum wages, the minimum wages that are specified by the United States Department of Labor. There are exceptions for different activity types. If you Google this, HUD factors of labor standards applicability, and you'll get to a resource page. Gosh, I hope it's still there. I check for it from time to time when questions come up about 7 or fewer, 8 or more housing units under one owner, under common ownership and management, because when you're doing residential rehabilitation or construction of housing, as rare as that is in CDBG, but if you're engaged in residential rehabilitation and you have 8 or more units, or in this case 7 or fewer units, whichever way you want to go on that, but there's a hard dividing line between 7 and 8 you don't want to cross. For housing, and if it's all under common ownership and management, it will trigger prevailing wage as well. It doesn't apply to the acquisition of property. Why? Because acquiring a property doesn't involve construction work. It requires escrow agents and a very large stack of money. Title reports, environmental reviews, right? If you're acquiring property, you want to make sure you get that environmental review completed before you acquire the property, and you may need to anticipate what you're planning to do with that property in your environmental review. Phased aggregation, remember that from the earlier slides. I digress. Prevailing wage contracts, $2,000 or more that are funded with $1 of CDBG funds. Once CDBG's involved in paying for that construction contract, if it's $2,000 or more, you're paying prevailing wage, hands down. Does not apply to acquisition of property. Let's go to the next slide. Wage decisions. Wage decisions are necessary. You need to know what you need to pay in order to have a hope of paying the workers appropriately, right? So To determine the prevailing wage that needs to be paid in your jurisdiction for construction work, you need to understand that the Department of Labor publishes different types of wage decisions that impact different types of projects. Installing a window on a single-story building is very different from installing a window on a skyscraper. Maybe not the best example, but let's roll with it. Recipients obtain the wage decisions through the state or on the web. Currently, you are going to sam.gov. Wage decisions have made it there. You have 4 different types of wage decisions: building, residential, highway, and heavy. Prime contractors. So as a grantee, you have a responsibility for determining the appropriate wage decision for the project and letting the contractor know which wage decision will be followed for that project. And there are different ways of accomplishing that. Some do it through their bid document and incorporate the bid document into the contract. Others will take a copy of that 30 or 40 pages of the wage decision and staple it to the contract that's signed, or include it in the PDF document portfolio that gets digitally signed, however we're doing it these days. But nonetheless, the wage decision is a contractual requirement. The actual wage decision, all of the pages of that decision need to be incorporated within the contract. You can't just put a link to the sam.gov site. That won't fly. Because it changes every week or two. You could have the potential for a modification of that wage decision. The HUD guide provides definitions of key terms. So we have a couple of HUD guides. You have a guide that's geared for contractors. You have a guide that is geared for local contracting agencies, another fancy term for grantees or state recipients, people investing CDBG funds into construction projects. So an employee is a laborer or mechanic on the project. An apprentice is an individual that's enrolled in a bona fide DOL, Office of Apprenticeship, recognized apprenticeship program. That's important because if you're receiving training through a legitimate apprenticeship program, you can be paid less than the journeyman prevailing wage rate. The prevailing wage itself, the trade, the work classification, fringe benefits, and all of those types of things are defined in the guidance and are very important when you're monitoring for compliance. Go to the next slide. All right, so when you're implementing Davis-Bacon, all bids and contracts subject to Davis-Bacon must contain standard clauses on requirements. It's the HUD 4010 Federal Labor Standards provisions or what you'd be looking for. Incorporate that plus your wage decision in the prime construction contract and you cannot go wrong. And the reason for that is that prime contractor is obligated to incorporate those same items, the Federal Labor Standards provisions and the federal wage decision, in all of their subcontracts, and those subcontractors must include those same items in their sub-tier contracts. The liability for payment of prevailing wage follows the contract level. So if you as the grantee fail to include the Federal Labor Standards provisions of the wage decision in your contract, court might rule, administrative law judge might rule that the grantee is responsible for the payment of prevailing wages. If you incorporated the Federal Labor Standards provisions and the wage decision in your bid document, in your contract with the prime contractor, then they are responsible for payment of prevailing wages on the project. The wage liability has been transferred to that prime contractor and should be transferred to all subs and sub-tiers so that you have an enforcement mechanism against the party that's obligated to pay the workers, which is their employer. Really important in many circumstances to hold a pre-construction conference to review the requirements of the contractor. If you are doing that, I'd encourage you to ask the contractor to invite somebody that handles certified payroll and payment to the workers to that conference, because you're going to be interested in knowing who that person is and perhaps sharing with them that this is in fact a Davis-Bacon project and there are certain requirements for paperwork that will need to be followed. There are submissions, protocols that need to be worked out. Talking to the construction foreman is maybe not sufficient if you're looking to educate contractors about Davis-Bacon at a pre-construction conference. So make sure you get the right people in the room and give them all the resources you can to ensure that they'll be successful, or at least promote awareness of the requirements. The prime or general contractor is responsible for full compliance with the prevailing wage, including lower tier subs. Contract administrator enforces requirements and provides information to the contractor. You, as the grantee, are responsible for reviewing certified payroll reports and conducting employee field interviews. Your labor relations officer in the field office or regional office will be asking you about this, and periodically monitoring to make sure that you're collecting payrolls and conducting interviews and reconciling those against wage decisions. Bottom line on all of this is you need to make sure the workers are paid and that they're paid appropriately according to the wage decision for the work that they performed on the site. Doing this work, you gain a little bit of expertise into, at least from the construction side, employment law and the importance of things like time cards and things of that nature. Let's go to the next slide. Other related labor laws, the Contract Work Hours Safety Standards Act, among other things, is what enforces the 40-hour work week. So the 40 hours in a week, if you exceed 40 hours in a week, you are entitled to overtime. There are certain exceptions when you're dealing with classified, non-classified employees. So for more on that, I would defer to the Department of Labor guidance. But for our purposes, if we're enforcing Davis-Bacon for laborers and mechanics on our project, if I see a guy or a gal or an individual that is working more than 40 hours in that payroll week, I expect to see them being paid time and a half for those hours over 40. Different states may have different laws. If overtime is kicking in at 8 hours in a day, as it does in states like California, you have another standard. So it's over 8 in a day or 40 in a week is the way that we trained it out in LA County. The Copeland Anti-Kickback Act requires payment once a week. So your payroll reports, guess what? They're weekly. Every single week, all 52 weeks of the year, that contractor is obligated to submit payroll reports to you. The first one's marked number 1, and the week ending date, let's say it's January 7th. The second payroll is number 2. The week ending date's January 14th. And so on, all the way until that contractor submits one that says number 674-final. Every calendar day from the first one to the very last one needs to be accounted for in your records, and you need to be reviewing and spot checking those to make sure that the work classifications are in your wage decision, that overtime's being paid, that other deductions are being documented, just a whole host of things in the Davis-Bacon training that you could touch on that are related to these other labor laws. Kickback Act is fairly simple, the way that I would define that, and we had this happen with a particular contractor on a project where they would pay the workers and prepare a payroll and submit it to the county. The workers were paid appropriately, but then there was this situation where the contractor was escorting the workers to the bank, and they're cashing the check at the contractor's bank, and out in the parking lot, cash was going back in the contractor's direction from the workers. That is a kickback. That is illegal under the Copeland Act. And you typically will learn about those things when you are conducting your employee field interviews. So you want to ask, are you giving any part of your pay back to the contractor when you're conducting those interviews? You learn a lot talking to construction workers out in the field about compliance and ways that contractors attempt to avoid their responsibility to pay prevailing wage. Fair Labor Standards Act establishes a federal minimum wage and also speaks to overtime requirements, FLSA. Let's go to the next slide. Switching gears from the Davis-Bacon requirements to the federal lead-safe housing rule. I want to talk about this a bit. The lead-safe housing rule applies to all HUD-assisted residential properties. So if you're engaged in housing activities for CDBG or CDBG-CV, make sure that you're taking a close, hard look at the lead-safe housing rule and the resources that are available to you both through HUD and through the Environmental Protection Agency. The lead disclosure rule applies to all residential properties, and so there are certain disclosures that are mandated in different situations. The EPA publishes a brochure. It's called Renovation, Repair, Actually, I'm sorry, that's the renovation, repair, and paint rule, which we'll talk about in a second. A couple of brochures. Renovate Right is one, and another one that cautions folks about lead hazards in their homes. They're used in different circumstances, whether you're talking about a rehabilitation project or if you're talking about like a tenant-based rental assistance program. So there's a lot of nuance in the disclosure and noticing requirements that you'll need to pay attention to, but effectively, and you'll see this for folks that do housing work, there's typically a lead disclosure that's attached to any residential lease or sales contract that's executed that lets folks know about the lead safe housing rule and what they need to do to protect themselves and to be safe. The Environmental Protections Agency's RRP rule applies to all residential properties and non-residential child-occupied facilities and preschools built before 1978. 1978 is critical because that is the year that lead-based paint, the sale of lead-based paint, commercial sale of lead-based paint was outlawed. So that happened in 77, January 1st, 1978. It's a bit of a safe harbor. I'm not sure if my grandfather still has that gallon of lead-based paint on the shelf or if it's even liquid anymore. But again, 1978 is a key date when you're starting to apply thresholds and applicability and looking at housing projects and what you need to do in order to follow the lead safe housing rule. RRP also requires renovators to take a certification course. So if you're engaged in owner-occupied rehabilitation, for example, and you're working on pre-78 properties, the folks that are actually contracting with you to remove lead-based paint, to conduct that abatement, to conduct even the testing up front, need to be certified, and you need to maintain documentation of their certifications with their reports, with their invoices, with their contracts. It is something your CPD representatives look out for when they're monitoring. So pay close attention to that if you're engaged in housing activities and RRP rule is triggered because you're on a pre-78 facility. If you're if you're dealing with a child care center, for example, it might be an example of a non-residential child-occupied facility like a preschool. So children under 6, not uncommon to see them chewing on things like windowsills or that little side window next to your door, next to your front door. They do the darndest things, and if there happens to be lead in that paint, it has profound and devastating health impacts for the children. So all of these other federal requirements are in place to protect us, to protect our residents. And so, you know, it's not just paperwork. It's not just a checkbox thing. These rules are in place to protect people and to better our lives. So worth diving into that and taking that seriously. Let's go to the next slide. More on the lead safe housing rule. It applies to those housing units built prior to 1978. 24 CFR Part 35 is your authority for all things lead safe housing rule. So if you want to know where in the regulations it says this or where in the regulations it says that, go to ecfr.gov, pull up Part 35, and do some keyword searching. See what it says about the particular term that you're concerned about, and educate yourself about what those requirements might be. If you're looking for additional information, also HUD Exchange and training resources and things that are offered by HUD's Office of Healthy Homes and the lead hazard programs. Lead evaluation, hazard reduction treatment depends on the type and level of assistance, the per unit rehabilitation hard costs, or the per unit federal assistance. So there's some thresholds and some evaluation criteria you can work through to see what your obligations are under the lead safe housing rule. Next slide. Evaluation of the activity depends on the level of assistance. So for those of you who've done owner-occupied rehab programs before and served pre-78 units, if your assistance is up to and including $5,000, you need to test the paint for lead. If it's more than $5,000 up to $25,000, you need to have a qualified firm perform a lead-based paint risk assessment and get a report That report should include their certifications and their license. It should also tell you where there are unacceptable levels of lead and what you should be doing about them to protect the occupants or future occupants of that property. If the project is more than $25,000, you are doing a full lead-based paint risk assessment. So that's going to be your slightly more expensive report with more in-depth testing, also quite extensive. If you are contracting with a different firm for lead-based paint abatement, tip I have for you, word of advice, is to take that risk assessment report and incorporate it into your contract like it was a federal wage decision on a Davis-Bacon project. Because sometimes you're not always in a position to adequately interpret what the lead-based paint inspector consultant is recommending. So it helps to include that report so that the contractors performing work on the project, if it's a different company, have full disclosure. Also make sure that those lead reports are in the hands of the property owner. If you're paying for a report and you have that report on file, share it with the homeowner, because if the rehabilitation doesn't move forward, they need to go ahead and disclose the presence of lead-based paint in a real estate transaction, in a sale. So go ahead and send them a copy of the report as well for their records so that they have knowledge of what's going on with their house. There are required notifications. There's a notice of lead hazard evaluation to the homeowner within 15 days of receipt of the risk assessment. So 15 days, you got to send that over. If you're presuming lead, you need to send a notice of presumption within 15 days, and there are some sample forms for this available as well. Let's go to the next slide. Addressing units that have the presence of lead-based paint. If your project's up to 5,000, the amount of assistance to the project, I should say, is up to 5,000. You're repairing surfaces to be disturbed using safe work practices and using a certified renovation firm. If it's greater than 5,000, up to 25,000, you're implementing what's called interim controls of lead hazards. So again, it's those safe work practices and that you have trained workers of a certified renovation firm that are doing that work. And then if it's over 25,000, you're doing full abatement. It's not just the surfaces that are to be disturbed or the surfaces that are not stable or encapsulated. It's basically taking all of the lead hazards out of that dwelling unit or that facility using a certified abatement firm and disposing of those properly. Last note on the reports: get a copy of the chain of custody report for any lead that's been abated and removed from one of your projects. Had a very wise CPD representative ask me for a copy of that once. Unfortunately, I didn't have a copy of that in the file. I was able to get it from the firm that we used. But until I was asked the question, I didn't know I needed it. So make sure that you all are following that lead from when they take it out of your walls or take it out of your property all the way to when it's disposed of properly in accordance with EPA regs. All right, next slide. All right, at this point, I'm going to hand it off to my colleague, Randall Mullen, and he is going to take you all the way home into Q&A. Randall, it's all yours.
Thank you, Clint. You know, if we were conducting this training in a conference room rather than virtually, this is where we would ask the participants to unbuckle that seatbelt, stand up, and stretch a little. I realize we've covered a lot of ground and we're going to cover still more. In the second half of this subject, other federal requirements, I will cover 4 topics. 1, relocation, 2, fair housing, 3, equal opportunity, and 4, Section 3. As Clint did, I'll describe the requirements and then the related activities for CDBG-CV programs using examples where possible. We'll begin with relocation. The Uniform Relocation Act is a federal law that establishes minimum standards for federally funded programs and projects that require the acquisition of real property, that is real estate, and affect displaced persons from their homes, businesses, and farms. It is triggered when real property is acquired or persons are displaced as, quote, a direct result, end quote, of acquisition, demolition, rehabilitation of a federally funded project. And as this slide indicates, it applies to government agencies, including those represented on this webinar. And of course, it's triggered if federal assistance is invested in any phase of the project. As such, the requirements apply to the related programs, including CDBG, as well as grants, loans, and other contributions that are made under those programs. Next slide, please. What is key to understanding the basics of relocation is knowing the answer to this question: who is a displaced person? As I indicated earlier, a displaced person can be a family, individual, a business, farm, or even a nonprofit organization. Now, what you see in this slide is an extreme example depicted in a GIF that shows a relocation that actually occurred during a CDBG-DR relocation project in Puerto Rico. An element to understand is that a displaced person is one who is permanently displaced as a result of that federally assisted project. The related protections ensure relocation assistance is provided to displaced persons to lessen the emotional and financial impact of displacement that is either caused by the CDBG assisted activity or another activity. Next slide. Next, I would like to distinguish between displaced persons on the basis of the type of properties from which they are displaced, that is residential or non-residential. As this slide indicates, displaced persons are eligible to receive a wide range of services and assistance. This includes advisory services and notices about their rights. And it's important to note, if a resident is not English speaking, you have to provide translation services to explain their rights. If a disabled blind person has to move, transportation will be provided. General information notice has to explain that they don't have to move immediately, but there is a possibility that they will move. Second, advance notice, that is a minimum 90-day notice to vacate, provided there is an availability of a comparable replacement dwelling. More on that detail momentarily. Replacement housing payments is the third element. It can assist the displaced person in finding new housing. And then fourth, even the possibility of constructing new housing as a so-called last resort, as it is expressed in the Act, when comparable replacement dwellings are not available in the market area. And then lastly, moving expenses associated with obtaining that very replacement housing. Next slide. For persons who are displaced from non-residential structures, a shorter list of services and assistance must be made available. Like residential properties, a displaced person in a non-residential structure must be formally advised of their rights. The notice must be for a minimum of 90 days in advance prior to the person having to vacate the structure. And one of two forms of financial compensation must be made available. One, payments particularly for small business to reestablish at another location and for related moving expenses, or a fixed payment arrived at in advance of the relocation. Next slide. In addition to those protections for persons who are permanently displaced by a federally funded project, families must temporarily locate, are entitled to similar services, but more limited assistance. And that would seem to make sense given that the relocation is temporary, not permanent. Families must receive the advisory services, including the previously mentioned notices, as well as temporary relocation assistance, if applicable, for a period of up to 1 year. The temporary relocation guidance entitles those families to remain in a decent, safe, and sanitary housing unit. That's the DSS acronym here. That is at least as affordable as their current housing. Next slide. Under the CDBG related programs, Clint and I find that temporary relocation benefits are more common than the permanent relocation benefits for displaced persons. And in our experience, we know that state and federal law has minimized the occasion of formally taking property from private parties for the sake of federally funded public projects. Nevertheless, it is important for grantees attending this conference to understand the basics around relocation and the Uniform Relocation Act. When relocation occurs, it applies to a broad range of purchases, and you see them listed here. There are 5: fee simple title, permanent easements, temporary easements necessary for the project, a life estate, as well as long-term leases, which are defined as 50 years or more. Next slide. There's also a range of purchasers. The grantee, and Clint and I both have experience working at the state and local level, where oftentimes it is a local government or a state government that is undertaking the purchase for a public project, but also nonprofits that receive the federal assistance from the sources of funding we're covering can be a qualified purchaser. And then there are also rare instances where for-profits are involved, but limitations exist in that respect. An agent or consultant acting on behalf of a grantee can also trigger the protections, and then even home buyers with federal down payment assistance. Next slide. Ordinarily, the type of acquisition that occurs on a CDBG related program purchase is voluntary. There are 3 possible types of voluntary acquisition, and this is where a grantee will not use those important and very significant powers of eminent domain.
Randall, I apologize to interrupt. Which slide am I supposed to be on? Because I went the wrong way.
Okay, we should be on, we just finished with the slide on purchasers. Could you go back to that slide maybe to re-establish where we are?
Okay, thank you.
One more. And then we went to voluntary acquisitions. There are 3 possible types of voluntary acquisitions as shown on slide 31 to make sure we're on the same slide. And they are those where the grantee won't use powers of eminent domain. Years ago, I was the director of housing for the city of Portland, Oregon, which decided during my tenure that they would not use powers of eminent domain, and all of their acquisitions became voluntary acquisitions. Or a grantee that doesn't have eminent domain powers. And numerous jurisdictions, in fact, entire states these days, are prohibited from exercising powers of eminent domain. Or the third type of voluntary acquisition occurs with purchases from a government agency where the buyer does not have eminent domain powers over that agency. And as a consequence, the purchase is a voluntary transaction. Next slide. The rarer occasion is an involuntary action that occurs under the threat or the actual use of eminent domain. That is a taking of property. And grantees who follow this rare course of action must take these 6 steps. They provide the notices to the owner, inviting the property owner to accompany them with an appraiser to a property inspection. Second, they receive a notification where the grantee has a proof of delivery indicating that the owner has received the written offer and just compensation and a summary of what is being acquired. 3, provide the URA notices and assistance to the occupants. 4, offer the market value for the property as evidenced by an appraisal of the property before negotiations even begin. Number 5, complete the purchase expeditiously. And 6, reimburse expenses for the transfer of titles such as recording fees, prepaid real estate taxes, or other expenses. It is important to note here that eminent domain or condemnation, it is often referenced, cannot be used for any acquisition not benefiting the public. So if you were working in an economic development agency at a state that is interested in acquiring property on an involuntary basis for a public use, that is permissible, but you cannot act on behalf of a private developer. Generally, this applies to economic development and related activities, and we would urge you to check before proceeding on eminent domain if you have not for housing and infrastructure related public use. And moreover, I want to note that those laws are always in a state of flux. An agency that I once headed, the Redevelopment Authority in South Carolina, once exercised the power of eminent domain. It no longer does so. The laws have changed and tightened up considerably over the course of many years. Next paragraph, or next slide, please. In addition to understanding the Uniform Relocation Act, the Housing and Community Development Act, HCD Act, was amended to include provisions specifically related and tied to the trigger of using CDBG and home funds specifically. This involves the demolition or conversion of housing units. Originally referred to as the Barney Frank Amendment, named for the congressman who proposed it, Section 104D addresses both, 1, people who are entitled to receive relocation assistance as low-income residents, and units that ensure one-for-one replacement when the stock of low and moderate income housing is decreased. Next slide. The second topic we will now cover is fair housing. As you probably know, the use of CDBG and related programs does require compliance with both fair housing and accessibility laws. The laws include a combination of both federal legislation, executive orders, an amendment to the HCD Act, and applicable state laws. You see on this list that such laws began with a title in the Civil Rights Act of 1964. Were strengthened with the landmark Fair Housing Act of 1968, and then followed by 2 executive orders in that time period. More recently, federal protections were extended on the basis of age under the Age Discrimination Act, and then Section 109 of the Housing and Community Development Act, which prohibits discrimination on the basis of race, color, national origin, disability, age, religion, and sex within CDBG program and projects and activities. Taken together, this full body of federal housing law and applicable state laws establish 8 protected classes served by CDBG programs. Grantees therefore must endorse these provisions and take on what FH&EO officials at the Department of HUD referred to as, quote, attitude and deed, end quote, with all regulations for fairness and equity in the provision of CDBG funded programs and projects. Next slide. Since the beginning of the CDBG program, grantees have necessarily agreed to not discriminate, nor and to affirmatively further fair housing in their communities. This requirement has particularly related to the conduct of affirmative marketing. Grantees should be aware that fair housing provisions apply to the locality as well as the whole program, and not just those activities that are CDBG funded, and that implementing fair housing activities is an essential part of CDBG responsibilities. The related rules have applied not to just CDBG funding activities. They are listed here, and this list demonstrates how far-reaching the scope of the compliance requirements extend. 1, maximizing housing choice. 2, lessening racial, ethnic, and economic concentrations of housing. And 3, facilitating desegregation and racially inclusive patterns of occupancy in public facilities. To receive annual CDBG funding, grantees have certified that they would fully fulfill this requirement through their consolidated plan and annual action plans. Also, each recipient has had to describe an affirmative marketing strategy, as well as analyze so-called impediments to fair housing choice. These activities may include independent actions by the grantee or cooperative ventures with others related to the housing industry, such as mortgage lenders, home builders, local nonprofits working in housing, and the list goes on. The grantee is essentially expected to take progressive actions to further fair housing with each CDBG project. Next slide. Although the certifications I referenced earlier and definitions that are covered by those certifications were strengthened 5 years ago, only to be relaxed and then restored when action to affirmative fair housing changed, the expectation to fulfill affirmative and affirmatively further fair housing has remained constant. As a consultant working with TDA Consulting, we have often advised cities and states on satisfying their certifications in different forms. And I will note that this expectation, while it has gone back and forth over the past few years, has remained constant. And as such, the existing regulations today do require grantees to certify as part of the consolidated plan that they will conduct an analysis of impediments to fair housing choice, referred to as an AI, take appropriate action to overcome the effects of identified impediments, and keep related records of that progress. More specifically, the grantees are to assume the responsibility of fair housing planning by conducting that analysis to identify impediments to fair housing choice within their jurisdictions, and then annually update that AI, as well as take those actions to overcome the effects of any impediments through their continued analysis and maintaining records that reflect recommendations that have been carried out and actions that have been accomplished with measurable results in turning those impediments into no longer barriers to affordable housing choice. For further details in regard to guidance, we urge you to look at the Department of HUD's Fair Housing Planning Guide, which provides considerable details in regard to the proper actions taken to fulfill this requirement. Next slide, please. As part of the body of fair housing laws, certain laws and provisions are also intended to ensure accessibility to public places, as well as publicly funded development projects. These measures afford greater accessibility to CDBG and related programs. Grantees must adhere to provisions, and these laws and regulations include, first, the Architectural Barriers Act. It requires that buildings and facilities built, altered, or leased with federal funds be designed according to standards that make them accessible. The Americans with Disabilities Act, which requires covered employees to provide reasonable accommodation to employees with disabilities and imposes accessibility requirements on public accommodations. Section 504 of the Rehabilitation Act, which initiated the standards of providing, you've heard this term before, reasonable accommodation to any person with physical or mental impairment. And provisions of the Fair Housing Act, which similarly afford protections and accessibility for such persons to federally funded housing. Because Section 504 offers specific guidance related to housing and community development, we'll now examine more closely how it assures accessibility. Next slide. As previously noted, Section 504 makes it unlawful to discriminate based on disability and HUD-funded housing programs. You see, the covered disabilities or impairments that are called out, specifically mobility, visual, hearing, and cognitive impairment. First, the recipient must take steps to ensure accessibility of communication. Second, it must include prohibitions against employment discrimination and ensure that reasonable accommodations are included in its written agreements with various parties to fund developments. And lastly, ensure the program accessibility is unimpaired for both housing and non-housing development activities. Documentation on the program level and covered projects includes a self-evaluation, a transition plan to overcome those barriers to accessibility, a list of interested persons who were consulted, a description of areas and buildings examined and any problems identified, and a description or identification of those modifications made and remedial steps taken to comply with the regulations. Next slide. Exactly how do these provisions specifically apply to housing projects? Clint made reference to different sizes of projects that are subject to certain environmental review and labor standards provisions. The same applies here to the application of Section 504 to housing. The new construction of 5 or more single-family housing units or multifamily housing units, and the substantial rehabilitation of multifamily rental housing with 15 or more units are all covered. And as you see here, substantial rehabilitation is defined in a common fashion. Rehabilitation that causes equal to or more than 75% of the replacement cost to be incurred for those housing units. For covered housing developments, 5% of the units must be accessible to persons with mobility impairments. And an additional 2% of the units must be accessible for persons with hearing and or vision impairments. Next slide. In addition to housing, Section 504 covers facilities that are assisted with CDBG and related programs. As with housing development, a facility must be accessible that it can be approached, entered, and used by persons with physical handicaps. Because a touchstone of this requirement is the so-called reasonable accommodation, the standards afford several options for improving program access. You'll find detailed guidance on the HUD exchange in this regard. Next slide. The third topic that I will cover regards equal opportunity. Hang on here, there are only 2 more topics left in this second half of the coverage of other federal requirements. As you see from this slide, various federal laws and authorities extend protections against discrimination and afford equal opportunity access under the federally funded programs, including CDBG. Next slide. Essentially, grantees are expected to comply with equal opportunity laws by providing equal opportunity in 1, the provision of service facilities and improvements. This ensures equitable program benefits. 2, CDBG related employment. And 3, all CDBG related procurement and contracts for goods and services. To document compliance, grantees are expected, of course, to keep records and ensure that a designated officer or representative assures that compliance and checks performance on an annual basis. Next slide. The fourth and final topic that I will cover now is Section 3. And I want to take a minute or two to cover it in detail, due to recent attention that is given to this element or requirement under the category of other federal requirements. First, Section 3 requires training, employment, and contracting opportunities to be made available to low-income residents and business owners of the project area for programs involving construction and rehabilitation. I use the phrase a project area. That's defined as the area served by your CDBG program. You're expected to make special efforts to engage persons from those areas when undertaking construction and rehabilitation projects. To comply, a grantee must first develop a Section 3 plan and then make outreach efforts to fulfill that plan, including targeted outreach to those residents and businesses in the project area, as I earlier defined it, and then advertisements that identify those special opportunities provided. I noted earlier that this topic has received a lot of attention recently, and that is because the Department of HUD issued new guidance earlier, actually last year, in CPD Notice 2021-09. So I urge you to visit the HUD Exchange and learn more about it. What did it do? Well, it creates more effective incentives for employers to retain and invest in their low and very low income workers. It streamlines the reporting requirements by aligning them with typical business practices and provides for program specific oversight. And it clarifies the obligation of entities that are covered by Section 3. On the whole, it provides additional clarity around what is expected under this important requirement and offers guidance to help grantees take positive steps to fulfill the intent and purposes of that section of the Housing and Community Development Act. We also want to note that you can register on Business USA or Google Play, even iTunes, and download the Section 3 app. A link is provided on the rotator at the top of the Section 3 website, the landing page at the HUD Exchange as well at hud.gov/Section 3. Okay, that concludes the second half of the presentation on other federal requirements, and we would now like to, you may advance the slide to questions, and we are pleased to note that about 25 minutes are left for us to cover a wide range of questions that have come in from the first half of this session regarding environmental review, labor standards, and lead paint, as well as the topics that I have covered. Clint, what questions do we need to address first?
Wake my system back up here again. I was off camera here. Okay, we have 6 open questions in the Q&A. Let's see here. Is there a question? Can a grantee sign up for HEROS, the HUD Environmental Review Online System, including states, or is it just for entitlements? Actually found the answer to that on the HUD Exchange website. There is a page there for HEROS. It's under Programs, Environmental Review, and HEROS, and it goes over the different HEROS users, responsible entity users, and HUD users, and partner users. Under responsible entity users, it says that HEROS is available for staff of the Office of Community Planning and Development, entitlement communities. So your responsible entities are REs in all regions. If you're working for an entitlement and would like to request HEROS access, you can do so using the access form that's on the website. Additionally, HEROS is only available to responsible entities, grantees, applicants, consultants, or users working with state-administered Native American or public housing on a programmatic basis. So what I'm taking from that is that in the nature of this question is, can any grantee sign up for HEROS, including states, or is it just for entitlements? It would appear that it is available for just entitlements, and that in terms of state items, it would be limited to state-administered Native American or public housing on a program-by-program basis. In the CDBG program, HEROS is available for CDBG disaster recovery and 108, but it's not available for the state small cities program. HEROS is open to CDB and CPD entitlement staff to complete environmental reviews for CDBG funded activities. So it doesn't appear that it is available in the state CDBG program just yet, based on what I'm reading on the HUD Exchange website, if I'm reading that appropriately. A lot of ifs and caveats there too.
Yes, that's my understanding too, but I believe there is an intent to eventually expand its availability. And also, I believe that there is an expectation that there will be additional training on HEROS sometime in the next year or so. Therefore, it would be important for grantees that have not yet begun to use the system to become familiar with it and then eventually take advantage. The website is very complete, and I would urge you to try to go through the tutorials and learn as much as you can. When Clint and I actually started completing environmental reviews a long time ago, it was a far greater undertaking that was not assisted with the remarkable amount of resources that HEROS provides. So take advantage of that tool and make the best of it.
We killed far too many trees, Randall.
We did.
It was quite disastrous. Let's see. Some real, I think, in terms of the questions, we've got some real specific situations that are coming through. We have a park improvement project. How do we do a functional ERR if we've not identified the amount of CDBG funds for each park? Only doing one park per year. Assuming that you're probably working for a city or a county, in that situation, I would proceed with evaluating the park that you know you're going to do. Like at the point you know you're going to do something, engage in the environmental review process and get that done before you actually are compelled to move forward with a particular park improvement project. The good news here is that for a number of the 17 environmental review factors that I discussed or made reference to, many of those can be analyzed on a kind of a larger scale than just the individual project site. So for example, if you're looking at floodplain, you probably have some familiarity with any special flood hazard areas that exist in your jurisdiction. So one of the best practices, or one of the, I guess, shortcuts that I would offer you is that once you do your first environmental assessment or categorically excluded subject to 58.5 review, and you have a real good sense for what's going on in your jurisdiction. There are some factors that you can readily rule out. You've already got documentation on hand to address them, and doing another categorically excluded subject to review for the next park that you identify next year, once you have a good sense for what the scope of that undertaking will be, may be appropriate. There are some concepts when you look at section 108, particularly in historic preservation, where people think about historic preservation as national historic landmarks or things of that nature, but fail to recall that things that are buried underground also are historic resources. And so if your project is proposing to trench or excavate or do grading on that project site for your park improvement, you may not have all of that information for your subsequent phases in terms of project aggregation. So if it's possible, if you have limited information about how the park improvements are going to unfold, and you're really not certain that you're going to move forward with this particular park and this particular scope of work, you really don't have enough information to be able to include that in your environmental review. My best advice to you in this situation is let reason and logic be your guide. So if in the example I provided during the presentation, if you know that something's going to happen, you're planning on it, which means you're talking about it with your director, you're talking about it with your commission or your council. It's an idea that's kind of out there that's being floated, and you're making plans to start engaging in it, and it's looking like it's going the CDBG direction. That's a good time to raise your hand and say, hey folks, we need to hit the pause button real quick. If you're serious about investing in this, I need to start the NEPA process and get that taken care of. Do we have enough information to define the undertaking? Where is it happening? What is happening? Who's funding it? How much is it going to cost? Because you really do need to kind of understand those things in order to get the appropriate level of review. But you also don't want to go so far in the process of that particular park improvement that you've already committed to a certain course of action. You've obligated CDBG funds for a purpose. So there's a bit of gray in there, but if you know enough to be able to start working on an environmental review and you're serious about the project and have all of those details, that's a good time to go ahead and get started. If it's still conceptual, hey, we want to do improvements to 10 parks, we're not sure which ones those are, you really don't have enough information to include additional parks. You might only really know about the one that's sitting in front of you today. And we were in national objectives earlier today, and we were talking about qualifying CDBG activities based on national objectives. And there's other analysis that you're doing for eligibility and national objective where you need that kind of information about which park, when, what's happening to it, who's benefiting from that park in order to qualify it for CDBG and kind of know that you need to do environmental. So I know it was a bit circumspect, but hopefully the perspective is helpful.
Clint, we also have a question from an anonymous representative who asks, I know environmental review is required for each project, but don't grantees use planning and TA funds for completing the environmental review? And the second part of that question is, then they submit the ER with the actual activity applications, right? The first part of that question is correct. Yes, a grantee generally will use planning and TA funds to complete the environmental review, but it's important to remember what Clint emphasized, and that is the grantee cannot take any choice limiting actions, and that would mean not incurring any cost. The application process will vary among grantees. If a state is operating a state CDBG program, it very well may have an application process at which point NER is included, but no project delivery costs can be incurred until that environmental review process is completed.
All right, we've got another question, and this, I love this question because it shows that our audience is thoroughly and completely engaged in the presentation, which is awesome. On the first slide, the OMB circulars or 2 CFR 200, the uniform admin requirements was listed, but I don't recall learning more about it. Did I miss that, or was that listed as an example of a cross-cutting requirement? I will say that it is listed as an example of a cross-cutting requirement because it infects everything that we do with our HUD CPD grants with CDBG. What I will say about that, so that we are meaningfully addressing that massive regulation that touches virtually everything that we do, is give you some practical advice on that. The uniform administrative requirements is vast. It has pre-award requirements, post-award requirements. It covers procurement. It covers reasonableness and allocability of costs, standards for financial management systems, indirect costs, direct costs, cost allocation plans, de minimis rates, you name it, it's in there. What I will say is this: a good place to start before you really do a deep dive on 2 CFR 200, or before you go to a section of 2 CFR 200 that appears to address what the guidance that you're looking for, is to start actually with the CDBG regulations at Part 570. Take a look at 570. So if you're an entitlement grantee, I would start at 570-502. And the section of that of the CDBG regulation is called applicability of uniform administrative requirements. What that's going to do is it's going to tell you a couple of things. First, it's going to say, hey, you need to follow 2 CFR 200. But it's also going to say, except in these specific circumstances, and it's going to list specific circumstances within the CDBG regulations where the CDBG reg in Part 570 is superseding Part 200, and HUD is specifying requirements for this particular federal award for the CDBG program. And there are some things that we do need to do differently. Not going to name them off the top of my head, but when you take a look at 570-502, you'll get a sense for what parts of 2 CFR 200 are applicable and which parts are modified by the CDBG reg. And similarly, I'm just scanning real quick in the state CDBG regulations, other applicable laws and related program requirements. It's going to be 570, 480 through 497 is going to speak to that.
Yes, and in each of the CDBG related programs, even the Federal Register notice on CV makes reference to 2 CFR Part 200. In this conference, you probably would want to listen to, and if you missed the earlier sessions on the various eligible activities, you might go back and scan for guidance related to not only the eligible activity regulations, but the corresponding elements of the uniform administrative requirements. For example, Clint and I yesterday covered public services, and we would identify the eligible activities and then add, where appropriate, references to 2 CFR Part 200 that raise such common elements as expenses being necessary and appropriate, costs being reasonable. And so Clint's exactly correct. The elements or guidance in those uniform administrative requirements are integrated throughout the CDBG regulations, and you can pick up particular points of connection as you listen to each of the eligibility standards, because the regulations issued by HUD for CDBG by necessity must conform with those uniform administrative requirements. Clint, it looks like we have a Davis-Bacon question as well, and it's anonymously provided or raised. Does Davis-Bacon apply where the entitlement awarded $300,000 to a subrecipient to administer an emergency repair program, but each project under this program does not exceed $7,500 each?
Is a fully loaded question, Randall. So let's follow it. Funds were awarded to a nonprofit subrecipient, and they're administering a repair program. So far, we don't have a construction contract. So we move past the $300,000 figure and go to the next level. Each project, so I'm assuming it's each of the dwellings that are part of the emergency repair program that are occupied by beneficiaries. So each of those projects has a programmatic assistance limit of $7,500 each. What I'm missing here in the repair program is I'm making an assumption in the question that we're talking about residential units. If it is residential, you need to apply the 8 or more units, 7 or fewer units standard and not dollar amount to that situation. If we're talking about emergency repairs to commercial buildings in your downtown area, that's non-residential. You'd want to apply the construction contract standard of 2,000 or more in the construction contract. Keep in mind that there are things that you can pay for in a CDBG funded project that are not construction, where CDBG funds are not assisting a construction contract. You want to be really careful. Look at those factors of labor standards applicability. Go through the CDBG section and make sure that you're dialed in on whether it's commercial or whether it's residential, so that you can apply the appropriate standard and understand that the applicability, which is the related act, the Housing and Community Development Act of 1974 is the related act. Federal projects follow Davis-Bacon. CDBG projects follow Davis-Bacon and the related acts. The related act, being HCDA of 1974, tells us when Davis-Bacon applies and when it doesn't. And so that's where the factors come into play. 2,000 or more in a construction contract. Residential properties assisted where they're under common ownership, it's all part of the same undertaking. You've got 8 or more units involved. That would be a Davis-Bacon residential project. So follow the contracts, understand the nature of the project, and then determine if Davis-Bacon applies to your emergency repair program. Commonly, owner-occupied rehabilitation, where you're going house to house and they're all owned by individual owners, it's not going to trigger Davis-Bacon because that project doesn't involve 8 or more units. And at $7,500 a piece, I should hope that that you're not spreading that across multiple units. All right.
We also have a question, Clint, related to the topic of Uniform Relocation Act provisions. It asks, a CDBG project requires permanent easement acquisition to move light streets or lights on a street from a sidewalk to private property. This involuntary easement acquisition could take a long time and cost a lot if owners ask for appraisals. How do we estimate a fair compensation that might prevent an appraisal request? I first want to point out that you are describing an involuntary acquisition, and by definition, that occurs under the threat of use of eminent domain, in this case for your public street and the lighting along that street from the sidewalk. It is necessary for you to provide an owner with a written offer and the just compensation. How is that just compensation determined? Well, it is on the basis of an appraisal. However, you can, under certain circumstances, provide that appraised value of the property in a manner that does not involve actually an appraisal request from an appraiser, but perhaps a representative from the agency that has similar qualified certifications and can, based upon ethics of that particular field of business, provide an appraised value. What is most important is to then make an offer of compensation that reflects the market value of that property. It would still be within the the property owner's right to request an independent appraisal by a third party, but it is possible to then proceed to complete the purchase expeditiously along that course. I would urge any grantee that is seeking to exercise that approach to confer with their HUD office, and which may in turn need to ask the regional office where the experts on acquisition and relocation can offer guidance. There's also a handbook that details those options. It's vitally important that you follow the routine, and whomever would offer such an appraisal have the necessary certifications that ensure that that is in fact an appraisal that properly establishes the market value. So I would urge you to check further in regard to the handbook and confer with the HUD office to make certain that you don't get tripped up on a procedural action that would further delay the acquisition of the permanent easements to complete the public works project that installs the new street lights and sidewalks along your streets.
Okay, I'm seeing that we are down to 5 minutes in our session. There's just a couple of questions here. I want to thank David Bess in Pekin, Illinois for submitting this one. If the city purchases land but has multiple potential CDBG and non-CDBG uses for that land, but subsequently decides that the already acquired land suits a CDBG eligible construction project, can the city move forward using CDBG, or is the city's previous ownership in the land inherently choice limiting? No, you hold land, you hold a resource, but I will say this, neither the applicant nor partners in the process, in other words, the city, are allowed to spend or commit CDBG funds for the purposes that would take place on that property that you already own, that you purchased, until you've completed your environmental review. The idea is that you're not making additional decisions, that you're not taking additional steps that would commit the CDBG dollars, that you're not spending CDBG funds or CDBG-CV funds until the environmental review is complete. There are definitely situations where we're using resources that are already owned, that were acquired for various other purposes with nothing in mind at all other than, hey, that property is available, let's get it, we'll use it for public good in the future, or an opportunity presented itself to your jurisdiction. So just at that point that the property is identified as being potentially part of that project, or that you intend to use it for that project, that's when you're going to raise your hand and say, hey, before we enter into an agreement saying that we're going to merge this property that we already own, combine it with some CDBG funds and build something that will benefit our residents, go through the NEPA review process, kind of figure out what it is that you're intending to do with it, get your environmental clearance, and then go ahead and enter into the agreement. Just from a legal perspective, don't commit or spend CDBG funds on physical activities until the review is complete. The fact that you bought it before shouldn't make a difference.
Clint, we may have time for one more question, and it relates to a labor standard, to a lead paint, and I'd appreciate your help in answering it. It asks, can a company that does lead testing also do the abatement, or does it have to be two separate companies?
Randall, I deliberately avoided that question because I didn't have the answer off the top of my head. While you were answering the right-of-way acquisition one, I was looking at 24 CFR Part 35 to see if I could find an obvious answer. All I can offer is a perspective here, and I see where you're going with that. I'm not certain whether or not that's a requirement, so I don't want to give you a firm answer.
Yeah, and I would agree as well.
Yeah.
And I think it's appropriate to confer with the HUD office in that instance.
Yeah.
But I also believe it illustrates a way that the uniform administrative requirements should influence many of the decisions that are made. And among those is the view that where a grantee has obtained the services of a a party that is conducting such activities as the testing, it would probably be appropriate to separate and check against that role and responsibility with a separate company that would actually conduct the remediation or abatement, simply because it better ensures that there is proper testing and appropriate correction of the conditions of lead paint. But
Yeah,
we would
yeah.
urge you to check with your HUD office.
Yeah, definitely check into it. All right, I agree with all of that, and I see that we've reached 6 p.m. Eastern, 5 p.m. Central. So we'll conclude the question and answer portion of the session. On behalf of Randall Mullen and all of our colleagues at the U.S. Department of Housing and Urban Development, all of the TA providers and presenters this week, we thank you for attending the session on CDBG, other federal requirements that impact CDBG. Thank you for your attention, your great questions, and also thank you for the work that you're doing in your community to help people recover from the pandemic. Very important work, and we're grateful to you for everything that you're doing with these resources. Take care and have a good evening.